Judgment in the matter of Volcafe Ltd and others versus Compania Sud Americana in Paris, SA.
Lord Sumption will explain the judgment of the court.
This appeal is about one of the obscurer corners of the law. It concerns the burden of proof in actions for cargo damage. Cases about the burden of proof are rare. This is because the burden of proof only matters when there is no reliable evidence on some issue. That means that the party who has the burden of proof on that issue must fail. The general rule is that the claimant has the burden of proving every fact on which he needs to rely in order to succeed. But there are some fields governed by special rules, and one of those is shipping. The claimants in this case were the owners of various cargoes of bagged coffee beans carried from Colombia to Germany on the defendant's ships. They were carried in unventilated containers in accordance with the instructions of the shippers. Coffee beans are a hygroscopic cargo. They absorb and then emit moisture. On a voyage from a warm country like Colombia to a cooler one like Germany, the moisture will condense against the roof and sides of the metal containers. To prevent the cargo from getting wet, the practice is to line the container with absorbent material such as paper or cardboard. It was the carrier's job to line the containers. What is alleged is that the carrier lined them with paper that was too thin or not enough paper, as a result of which the cargo was spoilt by condensation occurring during the voyage. The judge found that there was no evidence that would enable him to decide what the commercial practice was as to the number of layers or the thickness of paper that should be used. So it became crucial to decide whether the cargo owner had the burden of proving that the carrier negligently lined the containers, or the carrier had the burden of proving that he did the job carefully. The judge thought that the cargo owner had the burden of proof, but that as a matter of evidence, it was to be assumed that if the cargo was damaged, this was due to the negligence of the carrier, unless the contrary was demonstrated. So he decided the case in favour of the cargo owner. Then the Court of Appeal took a similar view, but revised the judge's analysis of the facts and decided the case in favour of the carrier. This contract of carriage was subject to the Hague Rules, an international treaty made in 1924 to which most maritime nations were party. It governs the liability of carriers for the carriage of cargoes by sea. Whether the carrier is liable for cargo damage depends on two questions. First, was there a breach of Article III.2, which provides that the carrier must exercise reasonable care in the handling of the cargo? Secondly, if there was a breach of Article III.2, is the carrier nonetheless protected from liability by one of the exceptions in Article IV? The exception on which the carrier relies in this case is for inherent vice, a technical term which means some characteristic inherent in the cargo which makes it unfit to withstand the ordinary risks of a sea voyage. The carrier says that the coffee beans suffered from inherent vice because of its inherent tendency to absorb and emit moisture. The Hague Rules contain no provisions dealing with the burden of proof on these particular matters, and so it's necessary to resort to the common law to decide what the answer is. The Supreme Court unanimously rules that the carrier has the burden of proving that it was not negligent for the purposes of Article III.2. Carriage by sea is a species of bailment for reward. In other words, the carrier is a custodian in possession of the goods. The established rule about bailees in possession of the goods has been clear in maritime countries since Roman times. The bailee has to prove that he was not negligent. This is because, having had the goods in his possession when the damage occurred, he is in the best position to explain what went wrong. There is no reason to apply any different rule simply because the contract in this case was subject to the Hague Rules. It follows that in the absence of evidence to show that the carrier used the right quantity and thickness of lining paper, the finding must be that he failed to take reasonable care of the cargo. The next question concerns the exception of inherent vice. It's well established that an exception, like inherent vice, does not operate if it was only because of the carrier's negligence that it damaged the cargo. The carrier in this case admits that the burden is on him to show that the cargo suffered from an inherent vice. But the carrier says that once he has shown that it suffers from some inherent characteristic liable to cause damage, it is for the cargo owner to prove that it was only because of the carrier's negligence that it actually did cause the damage. The Supreme Court, again unanimously, holds that it is for the carrier to prove both that there was an inherent characteristic of the cargo liable to cause damage, and that he was not negligent in allowing it to lead to damage. A cargo does not suffer from inherent vice simply because it has some inherent propensity, such as the propensity of this cargo to emit moisture. It suffers from inherent vice only if that fact makes it unfit to withstand the perils of the voyage. If reasonable care in lining the containers would have prevented the condensation from reaching the cargo, then it was fit to withstand the ordinary perils of the voyage, and there was therefore no inherent vice. It follows that the absence of reliable evidence on these points tells against the carrier and not against the cargo owner. The Court of Appeal found, disagreeing with the judge, that there was a standard commercial practice about this, and that there was enough evidence to show that the carrier lined the containers in accordance with that practice. However, in the Supreme Court's view, the evidence was far from clear, and the conclusion that the judge reached was one that was open to him on the material before him. The appeal must therefore be allowed, and the judge's order must be restored.